Welcome to Better HR in 10 Minutes, where we discuss an HR question in 10 minutes or less from the perspective of an EEO trainer and an employment law attorney. I'm the attorney, I'm Sarah Glasser.
And I'm the trainer, Rodney Klein.
Keep in mind, everything Rodney and I discussed today is not legal advice, and I don't represent you. Rodney, so we have talked about ADA so much. It's our favorite topic, but we're going to switch a little bit today and talk about is it fair to say adjacent? I don't know. Pregnant Workers Fairness Act. And so if I'm going to call it adjacent, so there's similarities and there's differences. So I don't know, talk to me a little bit about that.
Yeah, I think in a way, Congress just wanted to close a donut hole of sorts in the whole reasonable accommodation thing, because there's a lot of conditions that are connected to pregnancy that are considered disabilities under the ADA. They're covered under the ADA, but pregnancy itself wasn't. So I think they just kind of want to say, let's just kind of make this one thing. Well, sort of one thing. And so to a large extent, the Pregnant Workers Fairness Act is really similar to the ADA, and it uses much of the same terminology. The one thing that I just see, like on social media and other things, it gets a lot of traction is this whole idea under the Pregnant Workers Fairness Act of who's qualified. Now, under the ADA, we know that a person's qualified if they have a physical or mental impairment that restricts or a life activity, but also they're qualified because they need to be able to do the essential functions of a job either with or without a reasonable accommodation. Well, the Pregnant Workers Fairness Act has the same language. A person's qualified or covered under the Act if they can do the essential functions of their job with or without a reasonable accommodation. But then there's this other thing that seems to be causing quite a bit of disruption, and that is a person can also be qualified if they are unable to do an essential function of their job for a period of time. Now, there's a three-pronged sort of test in that, and that is their inability to perform that essential function temporary. Yes, let's say. Can they do it? Will they be able to do it again in a short period of time? And a short period of time is determined to be 40 weeks, which is basically the term of a pregnancy. Yes. But then the third one is can the employer reasonably accommodate this suspension of this essential job function for a period of time? And in this, I think this works very much like the ADA, because when we talk about reasonable accommodations, well, an employer has to provide the accommodation, unless doing so does what? Creates an undue hardship. So the same standard applies, and they were very specific by saying that the undue hardship standard for the Pregnant Workers Fairness Act was very similar to that under the ADA. So for me, I think, why did Congress put this in here? I don't know. I'm not in Congress. But I would say that they were probably just recognizing the fact that pregnancy is different than a disability. A disability, you would never think about waiving an essential job function because that would change the job. But with pregnancy, it's going to be short term. And so there might be situations in which you can temporarily suspend an essential job function. And I think that's something that most of us would just kind of intuitively think about if we had an employee that requested some sort of accommodation. Whew. So that's a long-winded way of me sort of outlining this thing. But I know we've had conversations about this, so I wanted to pitch it to you because I've made this sound like super simple. So tell me why I'm wrong.
Okay. Well, let me start before we talk about that. Let me talk about my evolution with respect to the Pregnant Workers Fairness Act, because I feel like it has been kind of I have not been, when I have been doing training and talking about PWFA, I've not been talking about it the same way since it came out. So when we first started talking about PWFA, I was training, I would say things like, y'all already do all this stuff. Like, you let people carry water bottles around, you give them bathroom breaks, and if you don't, you're kind of a jerk.
And did you really say that? Did you really call them jerks?
Sometimes, it depends my audience. Maybe I use like worse words for some of my folks who know me really well. No, but actually, I did have someone in the audience go, "Not everybody does." So Okay, so the law was made for that company.
Right.
But really, it was even the EEOC's infographic had the pictures of like the purse and the water bottle and the snacks. And I'm like, I carry snacks in my purse. Nobody's telling me I can't. And so it was this very like, y'all don't worry about this. It's gonna be fine. We're just codifying this sort of like this donut hole as you described it. And then the EEOC published the guidance, and the guidance had a lot of additional information in it that I think many attorneys were not expecting. And not we're not talking about this today, but another thing that was in there was this sort of description of the related medical conditions and how broad it was, and this sort of shocker like, oh, well, we're not just talking about pregnancy, we're talking about a lot of other things. But what we're talking about now is the idea that part of the accommodation obligation under this new statute can require employers to take away an essential function of a position for 40 weeks, which, by the way, it's 40 weeks on each side of the pregnancy, theoretically, which is 80 weeks, which is more than a year. And so that's a lot of time if you're talking about a very essential function of the position. And so I know what you're going to say, and you're already smiling. So you're going to say it, and you're going to say, well, look, you don't have to do that if it's not an undue hardship. But the challenge that folks in my position face is every time someone calls me and we're going through the ADA analysis, my focus is always on how can we make this work, and how can we figure out a way for this to happen and not get to the point where we're doing like a cost analysis to figure out whether something is an undue hardship, because that's a legally risky position to take. You're basically saying I can't accommodate you, and so we're always trying to not be there, and it can in a lot of instances have very significant impact on operations, especially if you got someone asking for something big like a reduction in their work schedule or to work remotely, when really their job, a huge portion of their job ought to be done in person. So not that I think every situation is going to be challenging, but I do think that there are going to be some very challenging scenarios under this new law.
Yeah, I think so too. I just think that the questions are still the same, right?
Agreed.
It comes down to whether it creates an undue hardship, which is a question that you're asking yourself if there's a disability. So it's a question you're asking yourself if it's pregnancy. I just think that the whole issue about the qualification thing, in other words, that a person may be qualified if for a temporary period of time they can't do an essential function. I don't know that I think that's just simply a recognition of the fact that pregnancy is something that's short term. And so as such, we would do something with pregnancy we wouldn't do with disability, because that's going to be typically long-term or permanent in nature. But the questions are the same. Does this create an undue hardship? And I think they were clear to saying that if it does, well, you don't have to provide it, but you do have to conduct due diligence to see. And those are the difficult questions, of course, but those are the difficult questions that have always been there if we're talking about disability.
Yeah, absolutely. It's not. That's never an easy analysis, whether you're talking about pregnancy or disability. And the good news about pregnancy in all respects is that it's temporary. Okay, well, I think that's probably it for today. I've enjoyed talking to you about this topic, and I think we've got other aspects of it to talk about in the future as well. If there's anything that Rodney and I could do for you, please don't hesitate to reach out.